Hello and welcome to the Rogers Brief for June 1st, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. This Rogers Brief is coming back after a week hiatus. Last week I was participating in the Cabot Trail Relay with a team, the Highland Hopefuls, based out of Bedeck. This is a relay, for those not familiar, that goes in 17 stages around the Cabot Trail. Most of the stages are around the 15-kilometer length running, and mine, I did the final stage, 18.67 kilometers, went from Middle River over Hunter's Mountain, which is a steep climb right at the beginning of the run, and then towards the last 4 or 5 kilometers, a lot of that run is uphill again, and then you finish off with a nice little downhill into Bedeck. Really well run in every sense. Event, the Cabot Trail Relay, big celebration afterwards, lots of camaraderie and good enthusiasm and encouragement. It was beautiful weather for the run too, so that was great, but that kind of kept me going from doing a video last week, but I've got lots to talk about this week, including a couple of appeal decisions out of Nova Scotia. One is this second-degree murder appeal, Gregory Purvis. That was a decision of the Court of Appeal this week on a jury trial and a conviction that was now overturned on appeal and sent back to new trial. I'll talk about that. The second one is Brandon McNeil, and this was an appeal of a decision that the trial of Brandon McNeil on sexual exploitation, interference, and assault charges of two young people was subject of unreasonable delay. And this this appeal encapsulates a lot of issues. This was a delay, and the reason for the delay was the unavailability of Judge Rickola Brinton and and the reasons for that were complicated and now subject of a lawsuit by Judge Brinton against the province and the Chief Judge Pam Williams. So talk about that and the appeal of the Crown appeal of the decision of Judge Bronwyn Duffy, fairly new judge to the bench, decision upheld on appeal. So we'll talk about that. Some other things to get to before that. What else do I want to talk about? So last night, I'll just mention I was at a dinner in the East Bay Legion down in Brian Comer territory. Brian Comer is the MLA for Cape Breton East. They do a really nice dinner every year down there, lobster dinner from Lewisburg Seafoods. Really well attended, and appreciate the invitation to come down and join them. Good to see my old friend Alfie McLeod. He's not up on his feet, but he's active, and he was doing his great job as always of live auctioneer. Raised a lot of money there last night, so that was great. We'll be up on, I think, we're waiting to see about Paul Palango for tomorrow night. This is the formerly known as the Sunday Night Show, renamed the Canadian Crime Weekly, just to encapsulate a little more about what we actually discuss. So Paul Palango has written 5 books now on the RCMP, former newspaper editor and reporter in Ontario. He and I discuss, along with Jordan Bonaparte, the host, issues that are in the news across the country. One of the things we talked about last week was the attack on killer Robert Pickton in a prison in Quebec. Well, the news in the last day now is that Robert Pickton has died from those injuries. He was attacked in prison by a broken broom handle and a toothbrush, it turns out. I've heard, and so there will be talking about that tomorrow night if we can track down Palango. He's traveling, and so to see if his internet is sufficiently strong where he is his exotic location. So we'll see about that tomorrow night. I'm sure we'll be posting on Facebook and Twitter to let people know whether that show's happening tomorrow night live on YouTube at 9:15. So follow up on that. Another thing just to quickly follow up on is a story out of the U.S. I talked about here 2 weeks ago, which was the arrest of Scott Scheffler, #1 golfer in the world, at the PGA tournament in in central U.S. anyway, Louisville, Kentucky. And he was arrested. There was an accident outside the tournament, and Scheffler was arrested for disobeying police instructions. Those charges have all been dropped. Apologies all around. Although the officer who said he was dragged by Scheffler's vehicle wasn't really injured that badly. Ripped his pants, I think. He was disciplined for not activating his body camera to accurately record the events. But there was other video of it which exonerated Scheffler, and so charges were dropped. He did not win the tournament, although he had 2 good rounds. He had a really good round the day of the arrest, and a good one round 1 too. So didn't seem to affect his game too much. The other, so a couple of stories I'm following, one I guess that's sort of national interest that's going to be developing over the coming months, is the province of Newfoundland and Labrador is taking the federal government to court over the equalization formula. The federal government has unilaterally extended the equalization formula to 2029, another 5-year extension, without the agreement of the province, and particularly Newfoundland. And the issues are the usual one, which is cost of services are more expensive in a rural province with a lot of rural areas and people to serve. Secondly, they say, and by the way, the Justice Minister in Newfoundland now is John Hogan, who was a year ahead of me at law school, really well-respected student, and my understanding is his reputation as a lawyer was quite good, and now he's the Justice Minister in Newfoundland. So I would watch this carefully. I think there's I'm sure there's something to this. Second thing he talks about is the resource revenue, which is always a contention in provinces, are not always, the degree to which they're included is often in dispute. What Newfoundland is saying here is that the costs of investing in oil production, in wind production, in green hydrogen, those are not taken into account that on the cost side, and also that resource revenue fluctuates a lot, so that should be taken into account somehow. And then the third thing is that excess funding, there always seems to be excess funding in this equalization calculation, that those excess funds only now go to recipient provinces and not all provinces, so they're disputing that. So keep an eye on that. Other thing that came out in the news this week, very quietly, but I'm sure we'll be talking about this next time we connect with Jordan and Paul, is the Mass Casualty Commission Implementation Committee, this which had been chaired by former Court of Appeal Judge Linda Oland, who was on a 1-year term to lead that organization. Has now been it has been now announced that Myra Freeman, the former Lieutenant Governor of Nova Scotia, is going to head up that organization, that committee. Critics might suggest that this committee has been criticized by me and others for not really seeming to do much. They're just sort of echoing what they're being told by the RCMP in the province and the federal governments, and not really digging into it in any way. And so if one was to be critical of the appointment of former Lieutenant Governor Freeman, one would say that somebody who's used to being in a ceremonial role might fit very nicely with this committee, but is not really what the committee, or well, more to the point, what the public requires of this committee. So we'll keep an eye on that. Before she was Lieutenant Governor, Ms. Freeman was involved in educational, the education system, and writing reports and recommendations there. So has some experience in the world of committees and writing reports and all that stuff. So we'll give her see how that goes. All right, so let's talk about the Trump verdict here for a minute. I've been watching this trial and watching with some interest some of the witnesses and the performances of the lawyers and all these things. So I was prepared. I wasn't sure how long the jury was going to take to deliberate. They did their closing arguments on Tuesday, judges' instructions on Wednesday, and the jury started their deliberations. Well, 11 hours of deliberating before coming to a verdict and finding former President Trump guilty on all counts. Okay, so 34 counts, but really one thing. It was falsifying records. He's so the payment of $130,000 to Stormy Daniels to keep her quiet was made by his former personal lawyer, Michael Cohen. And the question was, well, did President Trump know that Michael Cohen had made that payment? There's evidence that Michael Cohen made it sound, he presented it as invoices for legal fees, and Trump paid invoices for legal fees. But the question was, did he know that those were in fact going to be made, used as repayments to Stormy Daniels? The problem that Trump faced, and I think this is probably what the jury picked up on, was, in his book on making deals, the art of the deal, and some other evidence that came forward was that Trump was very diligent about signing checks. And one of the reasons he said, people don't rip you off if they know the boss is actually signing the check and looking at the invoices. And so that evidence of, all right, he signs the checks, he knows what they're for. And then, but then on the other hand, he was trying to claim, well, this $130,000 invoice, that was just legal fees. My lawyer presented me the invoice and it was paid. So that was, of course, Trump didn't testify to say this, but this was the evidence that his side was trying to present. Well, those two things, of course, don't mesh. They don't go together, and I think that's probably what the jury relied upon. I mean, there was lots of evidence, of course, and Michael Cohen was not a particularly great witness for the Crown or for the prosecution, but on that crucial point, I think the jury latched on to, well, Trump most likely knew if he was signing checks what they were for. And there was some evidence, too, that they had discussed the arrangements and how they were going to handle it. And the owner, David Pecker of the National Enquirer, was involved in all of that as well. So some salacious stuff, but it really boiled down to, was Trump aware of what he was paying for when he signed those checks in the Oval Office? Now, question is next, what about an appeal? And there does seem to be, now it's difficult to appeal a jury verdict to say that the jury just got it wrong. Like, they're not going to be able to appeal to say, well, Michael Cohen was a big liar, and so the jury shouldn't have believed him in this case. Hard to do that because you just don't know what a jury has thought about in their deliberations, unlike a judge alone trial, which maybe Trump should have opted for here, but didn't happen that way. A judge alone, the judge needs to explain his or her reasoning explicitly, whereas a jury, they just come out and say guilty or not guilty. But there's still an appeal available on the legal interpretations that the judge made, the legal advice or the directions that the judge gives to the jury. You can appeal on that basis. And in this case, there's some other issues too. One is that there's a novel connection between the state law of lying and falsifying the federal election laws. That connection has never been made before in any other state in the United States. The second thing is that the district attorney, so you have to, it was the intent to do the election, falsifying election records, which is, showing that you paid Michael Cohen for this, for legal fees, when in fact it was to reimburse Stormy Daniels. That's falsifying election records. The actual underlying crime was not revealed until very much close to the end of the trial, which is quite unusual. And as a defendant, you're supposed to have the right to understand what that novel connection is before the trial starts, so you can prepare for it properly. There'll be some question as to whether that's an appealable element of this as well. So we'll obviously keep an eye on that, and that's a big political story as much as it is a legal story in the U.S., as their justice system is very much a political system, much more so than ours. The district attorney, Bragg, in the Manhattan district, he's campaigning on this, saying that he's sued Trump 100 times, and so it's very, very different. Last thing I want to comment is just the lawyers. So the lead prosecution lawyer, Joshua Steinglass, and the lead Trump lawyer, Todd Blanche, you just expect so much out of these top U.S. Criminal lawyers, and surprisingly to me, these lawyers were getting a lot of criticism for their performances. Steinglass, the prosecution's who did the closing for the district attorney, went like 5 hours, and many commentators were saying that was way, way too long. That the jury was zoning out. They were, trying to stay awake. He went through everything in minute detail, and then he did it again. Like he went through it, and then he's like, all right, basically started over again, and he gave his argument twice, and had asked for that indulgence to be able to do so. The judge gave it to him, and that's not an effective way to make a closing argument. You want to, keep the jury's interest strong and finish strong. You don't want to sort of drift off with your final points and just sort of making sure you hit every base. You want to make a strong statement and make a good closing argument and sit down. You don't have to take too long. Todd Blanche, the Trump lawyer, he was criticized by the judge for telling the jury, you can't send him to jail. Well, it's not up to the jury to decide whether what the punishment's going to be if they find the person guilty. That's up to the judge to find the person, sentence them to jail. Trump's not going to go to jail, but to sentence them to jail, to sentence them to probation, to fine, whatever the sentence is going to be. So the judge interrupted Blanche to say, you know better. You've been doing this a long time. It's impossible for, I can't believe that was an accident for you to have put that out there, knowing that it was improper to put that to the jury. So, it can be a strategy, but anytime you have the judge interrupting you to say, listen, you should know better, you shouldn't have done that, that just doesn't, a jury, an audience, everybody that's watching is going to think a little less of you for doing that. You just, it's the temptation is there to sort of throw in a comment that you can't say. You're going to get rebuked for it, but it's already out, so now the jury's heard it. But not a good performance. The other, and just jumping back to when he was cross-examining Michael Cohen, Todd Blanche, there were 14 sustained objections to his questions. So again, it interrupts the flow of a cross-examination, doesn't help, is not something that a top lawyer would be expected to do. So interesting there. Okay, so that's enough of that. So let's go to these two Nova Scotia cases that I want to talk about. These are both decisions out of the Court of Appeal. The first was the appeal of Gregory Purvis, and this was an appeal of second-degree murder conviction, and was convicted of, this is a jury trial, of killing Derek Miles in January 18th 4th of 2018. Miles was alleged to be a drug dealer, and Purvis was not, Gregory Purvis was not connected to him per se, but his nephew, George Jr. Purvis, was alleged to have been working with or helping out at times Derek Miles in his drug business. There was a suggestion. Miles had been, I think, busted at some point, and there was some suggestion on social media that George Jr. Purvis was the rat that had talked about it, and so George Purvis Jr. heard this and wanted to go talk to Derek Miles about it. Picks up Gregory Purvis on the way. A third person too that hopped in the car just wanted to go with them to go get some beer, and the evidence was that they laid a brutal beating on Miles after confronting him in his apartment, and left. He was still alive when they left. Died later. So he was found guilty. So George Purvis Jr. Had pled guilty to manslaughter, claimed he was just in the room when they got there, that Gregory Purvis just started beating on Derek Miles and kicking him, and there was broken ribs and collapsed lung and a bunch of other things, head injuries and such, and that he had nothing to do with it. That was George Jr. pled guilty to manslaughter. So there was some issues. So when the police picked up Greg Purvis, they had a lengthy interrogation. Throughout that, Purvis was asserting his right to silence, and he never did testify. So the issues were at appeal that some portions, I guess, of the interrogation were held out, but much of it was in there, including a lot of comments from the police like, oh yes, Greg Purvis, you're a fighter, you've been around for a while, you're kind of one of these old school guys. So there was a lot of comments that were left in and that the jury could hear, suggesting basically that Greg Purvis was a tough guy, had been around the block, he knew how to handle himself, knew how to use his hands, all that kind of stuff. So gave an impression that he was the kind of guy that might engage in this kind of behavior. Second was the use of the guilty plea and the treatment of George Jr.'s guilty plea, and the Court of Appeal found that the instructions to the jury were unclear as to how that guilty plea should be used, because there's still multiple theories that could be adopted based on his guilty plea. And just because you plead guilty to something doesn't mean there's only one possible reason why you pled guilty to that. There could be still different versions, because there was a lot of dispute in this. And the third part was there were two others that testified. George Sr. and his wife Mary Ann Purvis testified. George Jr., George Sr., and Mary Ann all had criminal records. And so the judge was supposed to, and did give a what they call a vetrovac warning, which is a warning to the jury to say, listen, these people, they have criminal records. You have to be very careful when accepting, or whether you accept their evidence, especially where it's uncorroborated evidence. And George Jr.'s evidence was basically uncorroborated. There was no evidence of exactly what, there's nothing to corroborate his evidence that he had gone in and only just stood there while Greg Purvis did everything and all these things. So the instructions to the jury were not proper on that. There should have been a stronger warning. The Court of Appeal said that their evidence was unreliable and they were unsavory. The final thing was the instruction on what they call the mens rea, the mental element of the offense. So this relates back to the intention of Gregory Purvis, because when they left, George Jr. says that Derek Miles was alive. He was moaning and groaning. He didn't think he was going to die. He didn't think that Greg Purvis thought Derek Miles was going to die. And so you could say, well, the intent wasn't there to murder. So potential for the conviction maybe shouldn't have been for second-degree murder, but rather for manslaughter, which manslaughter, if you intend to do what you do, so you intend to hit somebody and then it leads to them dying, well, you still intended to do what you did, even though you didn't intend to kill. That would be manslaughter. If you intended to kill them or were reckless as to whether what you did was probably going to kill somebody, that could be second-degree murder. So there was a mistake, the Court of Appeal says, in the instructions on what the mental element of the offense was. So all of those things. So sometimes when a judge makes a mistake in instructions, but the evidence is overwhelming that the person was still guilty, even with those mistakes taken away, then the Court of Appeal could have just still said, well, we affirm the conviction. In this case, they're sending it back to trial because they said, well, we don't know what a jury would have done with proper instructions. So that was the Greg Purvis appeal. That'll come back for appeal. So the last one, oh yes, there was also an allegation of ineffective counsel, and this was Jonathan Hughes. Interesting kind of a situation here, because now the Court of Appeal found that, he could have done better, especially on the issue of Greg Purvis's statement that his counsel should have objected more to what was going in and didn't, and also that counsel did not cross-examine George Sr. and Mary Ann on their criminal records, didn't insist on a Vetrovac warning. Now, Jonathan Hughes said, and maybe rightly, made a strategic decision on that one, that when you give a Vetrovac warning, the judge then has to go into what parts of the evidence are corroborated, which parts are not. And Hughes said in his affidavit about his performance and about his thinking was that he was worried that the judge reinforcing parts of their evidence that was corroborated would have had a negative effect on Greg Purvis's defense, and so it was a strategic decision. Court of Appeal was lukewarm on the strength of that, but they did not find that he was ineffective as counsel. Ultimately, they said it was up to the judge to safeguard the right to a fair trial for the defendant, and that was so it was on the judge, Denise Boudreau, not on Jonathan Hughes, the defense counsel. So new trial coming up on that one. One would have to think, given the evidence that was in there, that a properly run trial is likely going to result in a conviction, but that has yet to come, so we'll see. Last one I want to talk about, this is the case of Brandon Miller. Brandon, he's now Brynn Milner. I'll get to that. Brandon McNeil, perhaps notably the nephew of the former premier and son of the former Halifax chief of police, has now decided to change their pronouns and go by Brynn, B-R-Y-N-N, Milner, M-I-L-N-E-R. Was charged with sexual exploitation, sexual interference, sexual assault of two young boys, I think around in the 10-year-old kind of range. Trial took place in July, August, and September of 2021, 3 days just spread over those different months. Closing submissions were written submissions in October of 2021, and the decision from Judge Rickola Brinton was scheduled for November 25th, 2021. Did not happen. The judge did not deliver a decision, and then in April of, so they were waiting. Defense counsel and Crown were waiting to see what was happening. They weren't getting much information. They were told that Judge Brinton was on short-term leave without much detail given. And then in April of 2022, they were advised that the judge was on leave indefinitely. And so there was some hope, I think, still at that point that the judge would return and give her decision. The Crown and defense, but it was not until 2023, February 2023, they had scheduled some provisional dates and all these things, that they were told definitively that the retrial would go ahead under a new judge. Well, at that point, defense made an application for what they call deliberative delay, a charter right under Section 11 of the Charter. You have a right to be tried within a reasonable amount of time. And Judge Bronwyn Duffy, a newly appointed within the last couple of years judge, found that there was a charter violation and issued a stay. Court of Appeal agreed and that it was unreasonable. So we had from October 26, 2021 until February 14th, 2023, 15.7 months of delay attributable to the court, to the judge, and so not attributable, in other words, to the defendant, and so their right was violated. Court of Appeal agreed, had no difficulty with the decision of Judge Duffy. Interesting in a way. I thought when that decision came out, I thought it was a solid decision. I didn't think it would be appealed. The Crown did appeal it, and maybe testing out a new judge, but the decision has withstood the critical eye of the Court of Appeal, and they've affirmed that the stay will be in place. Some of the things they discussed were that really no reasons were given or vague reasons were provided to counsel, and so there was no basis upon which counsel, the Crown particularly, could have asked to quickly have this move ahead through get another judge in to make the final decision. So we've heard since, of course, now that Judge Brinton has sued the province of Nova Scotia and Chief Judge Pam Williams. She had some complaints because what had actually happened was Chief Judge Williams wanted to be able to say to the public that all the judges are vaccinated, that everybody is taken the COVID vaccine. Judge Brinton had not done so and didn't want to say so, and was trying to figure out some modification to allow her to practice, do some, remote judging, video court appearances from her home or whatever. And that was not acceptable. So there's some blame to be shared here, certainly, because, I was critical at the time that the judges were revealing their vaccine status and saying that they were all going to be vaccinated. I thought that was difficult or unnecessary for them to do, at least because it was probable, I thought, that these vaccine mandates would come before the court and require decisions to be made, and there we'd have the judges themselves agreeing to a vaccine mandate. That would put them in a difficult situation if they were trying to determine the legitimacy of mandates for others. But that's what happened, and Judge Brinton didn't want to get vaccinated. But she has a bit of a history too. When she was first appointed as a judge just a few years ago, she was criticized. There was a Crown prosecutor who was openly gay who criticized her because she had a reputation of comments, very sort of Bible-thumping, fundamentalist kind of anti-gay comments as a lawyer when she was practicing at Legal Aid. And in fact, even after she was appointed as a judge, there was a video from 2022 of her, doing a a talk within her faith community discussing physical discipline and how that is a loving thing to do for a father to do. Anyway, so now she's suing because of Judge Williams's publicity of the situation, or her treatment and refusal to let Judge Brinton, do modified duties. Suing for $5 million and to be paid her $260-some thousand a year salary until her retirement age. So that lawsuit hasn't been in the news for a while yet. We'll see. So there's lots of blame to go around, and questions about delays and what can be done to use judicial resources much more efficiently. I've been thinking about this a lot. I've been having a couple of applications recently on sexual assault cases where in the old days, if you wanted to use somebody's text messages back and forth from a complainant to an accused or to whoever, you would just use them, and you couldn't use them to to suggest that these, they call them the myths in sexual assaults, that somebody's more likely to give consent, or that if they've given consent before, that's ongoing, or any of those things. There's myths there that you can't use messages for, but you can use them for other things. Well, now, if you're going to use messages, records of these nature for any reason in a sexual assault trial, you need to make an application in advance. So I've been involved in a couple of these things where, you take a day of court, you take many hours of judicial resources to make these decisions and review the records themselves, and it's a waste of time when it could be done by the Crown Prosecutor, who has an obligation to promote a fair trial. And during the trial, the judge is always alive to these issues and can make decisions on the spot too, as to the proper or improper use of any of those records. So that's one reason for a delay. Another one, just so as I was looking through the Purvis decision, Court of Appeal decision, guess how long it was? 72 pages long, written by the Court of Appeal judges. How long would that take? Imagine how long it takes to write an excellent, flawless 72-page paper, because that's the goal in these cases. I mean, they don't want to, could be potentially reviewed by the Supreme Court of Canada. You want to have a well-written decision. Even the Brandon McNeil decision, I think that was 25 pages. That's not on the super long side of it, but it's a long decision. So some issues there as to the proper use of judicial court resources and how that could be made more efficient. But it's all leading to delays, and it's unfortunate. The Brandon McNeil case, he's up on other charges now for theft, I understand, and all that stuff. But there's no justice for for the two kids and their families and everything that's happened there. So that's on Judge Brinton. That's on the judicial system itself, and some of the inner workings and inner disputes of the provincial judiciary. So that's how that can go. All right, so went on a little longer than I thought today, but those are some interesting stories. I thought I wanted to take a little dive into them and go through those cases. So in case we don't gather tomorrow night with Paul and Jordan, at least there's a little extra content there. So otherwise, I'll be back next week with some more stories to follow, and look forward to all that. So I hope everybody is enjoying their 1st of June. It's a decent day outside. Hope everybody's enjoying the weekend, and until next time, thanks again for watching, thanks for listening, and we'll see you next time.